My lord, this is a reappeal, my lord. It may be listed on 3rd of January, my lord.
Why third?
My lord, earlier, my lord, I had filed a writ petition,
Oh.
which on the 6th, my lord, I have withdrawn it with liberty to refile because there was some technical defect. So I have refiled.
But, I have been prepared for listing of the contempt appeal. Contempt appeal we have filed today. Already I have given the filing number. I prefer list taking up the matter tomorrow.
Why any urgent?
It's a contempt appeal. Ultimately, the learned single judge has held and that he has committed contempt and accordingly drawn contempt. It will be difficult on his part. Tomorrow.
May I please, Your Lordship? May I please, Your Lordship? Lordship, I beg to mention for listing of petition, Lordship. Matters related to Services Act, Lordship. Why the petitioner has taken a loan of 5,30,000, Lordship. Out of this, 3 lakhs already paid, Lordship. But due to some business fallen down due to COVID-19, Lordship, he has not paid the remaining amount. Now the responding authorities has issued the e-auction sale notice to the petitioner's land and building, Lordship. So the petitioner will be nowhere, Lordship, and the auction will be held on 3rd January, Lordship. So my humble submission, Lordship, may I be listed, Lordship, tomorrow, Lordship. I love it.
May I please your lordship, with the consent of the other side, my lord, I am mentioning, my lord, item number 16, my lord. That matter, my lord, this matter is pending before the Honorable Supreme Court, my lord, at present. So kindly, this may be deferred today, my lord. Kindly list after BO vacation, my lord.
You're appearing for?
For my lord state, my lord. I am additional PP, my lord.
On request made by Mr.
B Sharma, my lord.
B. Sharma, additional PP. For the state of Assam. Reached on 24th,
After BO vacation,
24th.
my lord.
Lordship, I beg to mention one WA, ring number 159 was 23, which is tagged with another W17423. It was supposed to come after 4 weeks. Last listed on 8/11/23. Kindly may come in the first week of January,
Yeah.
3 or 5th.
10th.
That's all right.
But I pray for listing of an IA, my lord, for correction of an order. On 15th, your lordship has passed an order protecting the respondent number 1 in the writ appeal instead of the appellant. Though it was pronounced in the open court. So that minor correction is required, ma'am. Regarding, my lord, relating the appointment of assistant professor in AIMS Guwahati, my lord. So there, my lord, the protection was given to respondent number 1, though the IA was filed by the appellant, my lord, with the presently she is working, my lord. He has not been selected. Well, tomorrow, my lord. Okay. I'm all right.
May it please your lordship, I beg to mention item number 3 with the consent of the other side, senior counsel T.J. Mahanta. We seek adjournment for 3.
Yeah, putting on behalf of,
The petitioner.
on request made on behalf of S. Bhattakur, counsel for the
May
petition.
lordship be kind enough to give the date after BU vacation.
List on 22nd January.
Obliged your lordships.
May I please, your Lordship? Lordship, I will to mention item number 11 of daily list. Lordship, may this matter be passed over for the day.
Yeah, for? Yeah, putting for?
Petitioner, K. Sharma.
On request made by K. Sharma, let me counsel for the appellant. List, when?
The BU vacation.
29 January.
Obliged.
Item 1 for both.
May it please your lordship. Your lordship, the petitioners herein are the former students of Tezpur Academy High Secondary School, Tezpur, your lordship. Your lordship, they are aggrieved by the fact, your lordship, that the school playground has been acquired by the district as well as the Tezpur Municipal Administration for parking place, your lordship. And there is this decision, irrational decision of the district administration as well as the municipal administration has raised several eyebrows in the town, your lordship. And they being offended that of this school, your lordship. This school is a very historic school, your lordship. It was formed in the Jonaki era, an era of cultural and your lordship, cultural renaissance in Assam, your lordship. It was established, your lordship, against the Cunningham Circular, which asked the guardian of the student at that time to give undertaking not to agitate against the British administration if they want to get admitted in government school. So several academic schools were established in the state of Assam at that moment in 1930, your lordship. So it has got historical importance, your lordship. Suddenly such decision will, your lordship, if suddenly the parking places are shifted to the playground, your lordship, then your lordship, it will have a disastrous impact upon the educational environment of the school, your lordship. So, your lordship, they have submitted several memorandum to the respondent authorities, your lordship, and those things have been widely circulated in newspapers also, your lordship. And but your lordship, they are progressing at a fast speed, your lordship, and
Where's the letter?
your lordship, that's I have stated, your lordship, that though we saw the letter, your lordship, that was not provided to us, your lordship. But I have mentioned the letter number, your lordship. Your lordship will find on page 8, your lordship. And I have given the averment in page 9, your lordship. The petitioners apologized for not being able to annex the impugned letter as the respondent authorities did not send a copy of the same to the petitioners. They, however, managed to gather the information regarding the content of the letter, your lordship.
Yes. Yeah, just check it out. Yeah, yeah. Is it in the PIL format?
Lordship,
Your PIL?
lordship.
Is it in terms of the PIL rules of Guwahati High Court?
Lordship.
Yes, what do you have to say? Yes.
So first they have to annex the impugn order, impugn letter, lordship. And after that only you can.
They are saying that they have not been able to get it.
Lordship, if they have the knowledge about the letter, then they should have to get a copy, lordship.
How will you get, your lordship? We are not provided with the letter. The letter was issued by the respondent number 7 to the respondent number 9. The chairman of the municipal administration to the principal of Tejpur Academy High Secondary School, your lordship. So there is no question, your lordship. When we are informed, your lordship,
You can get it from the respondent number 9.
your lordship, respondent number 9 is not willing to share with us because he's a government servant, your lordship. And your lordship, he may face problem, your lordship. That's the problem, your lordship. And they are very adamant, your lordship, and arrogant in their approach, your lordship.
No, I don't know. No, we'll issue notice for the time. Yeah, we'll issue notice. But Mr.
I, Hussein.
When I come for petitioner, issue notice. Who appears? Urban Development,
I'm appearing, Lordship.
MS.
S four,
Cornwall, and Standing Council Urban Development appears for respondent.
1, 4 and 5, Lordship.
1, 4, and 5. School Education, R Majumdar, you have R Majumdar, Standing Council. School Education Department for respondents, 2,
2, 3, 6, and 9.
3, 9 also,
9, my lord, it's a provincial high school, so.
Nine. And Municipal Board,
They appear on standing council. About
petitioner to take steps for service of notice on the respondents have been made by registered post within 1 year.
Your lordship, till your lordship further orders, your lordship, any decision if taken, your lordship may not be, they may not execute it, your lordship. It will have a disastrous impact upon the students, your lordship. Your lordship, the honking of horns, such a parking of such magnitude, your lordship, it will create nuisance, your lordship. The interest of the students will be, your lordship, jeopardized, your lordship. Your lordship. So till then, your lordship.
Yes, what do you say on this?
Lordship, till,
On the one hand, my lord, a parking lot in a school play field, my lord, I'm not very sure about that. Otherwise, my lord, the parking lot is.
Only thing is, we don't have the letter, on what basis are we going to issue? a letter?
Your lordship, if a decision has been taken, your lordship may observe that way, your lordship, but it is a matter, your lordship, it has created a lot of, your lordship.
The respondents in the interim, the respondents are directed not to act. No. That if any decision has been taken in terms of the letter dated 25/3,
23, 5, 23.
23/5/2023. No, cancel it. The respondents, who is the official respondent?
Your lordship, respondent number 7. Respondent number 7 issued the chairman of Tezpur Municipal Administration, your lordship. Tezpur Municipal Board, your lordship, issued the letter, your lordship.
Not to act. In terms of any decision that may have been taken in terms of the letter dated 23/5/20.
Your lordship, later dated
23, 5.
23/5.
Oh.
Like that.
Oh, list of this forward.
Item 2.
Please, your lordship. Contempt matter, my lord, alleging violation of the judgment dated 9/8/2023, my lord. Lordship will find the operative part at page 28. Here, what had happened, my lord, there was some dispute regarding the distance traversed by a contractor, my lord, FCI. So the direction was to make the payment for the entire distance, my lord. Page 28, payment of extra mileage, para 14, my lord. Payment of extra mileage shall be made to the respondent in terms of the judgment dated 13/9 rendered by the learned single judge. That your lordship will find at page 19, my lord. The direction was to pay within a period of 60 days, my lord. Till date, nothing has been paid, my lord. Page 19, para 21. The writ petition succeeds and it is hereby allowed. The writ petition is disposed of with a direction upon the respondent numbers 1, 2, and 3 to release the payment, balance payment to the petitioner in respect of the additional distance of so-and-so at the date of so-and-so within a period of 60 days from the date of receipt of the certified copy. Now, thereafter, they went on appeal. The appeal was dismissed, my lord, by 9/8. We served copies, my lord. Lordship finds at page 29 on 14th of August.
Third, Mr.
M. Dekaman.
M. Decker, N. Decker, London Council for the petition, issue notice. The petitioner to take steps for service of notice on all the respondents by reasonable possibly within 1 week.
Obliged.
Least of the 6 weeks.
Item 4.
What is your lordship?
But in this matter, there is a stay regarding the schedule. There are two properties here which were under the possession rank. Well, there is a schedule A property and B property. During the time of physical possession, well, some anomaly is found in the boundary of the schedule A property, with which he was aggrieved. And my lord, we are proceeding to cancel that auction. There is a stay from this order from this honorable court regarding schedule B property. My lord, we need some more time to correct those anomalies. Let the interim order as far as schedule B property that may continue, my lord. In the meantime, we have no difficulty regarding that. We are taking steps in respect of schedule A property, but the auction already that was done, that will be cancelled. That is my instruction. Lordship will find at page 15, my lord, there are two properties.
Yes. No, the interim is only with regard to schedule B.
Schedule B property, because my lord, my lord, unless we correct the anomalies, admittedly, my lord, we cannot proceed with the.
But Mr.
K Das, lordship.
K Das, learned counsel for the petition.
I am for 1 and 2.
Mr. A. Ganguly, learned counsel, appearing for respondents 1 and 2.
I am for 3, madam.
Submits that the respondents are trying to remove the anomalies with regard to schedule A property.
April.
And therefore praise for another, praise for
4 weeks.
accordingly, list this matter.
Lordship, interim may continue, lordship.
Yes.
On 29 January. Interim order passed earlier to continue till the next.
I am waiting for the response number 2.
Who is the caveat here?
But we are filed it. That can be
A.
disturbed.
Ganguly, learned counsel. David stands.
29 1.
In this petition, my lord, the petition is challenging the constitutional validity of section 16(2)(c) and D of the, my lord, the Central Goods and Service Tax Act. Well, under the GST law, my lord, when somebody purchases goods, then he gets the input tax credit of the tax paid to the supplier. Now, I purchased the goods, my lord, from a registered dealer, and he issued me tax invoice by charging the tax, and the tax was paid to him. Now, I can, my lord, claim the input tax credit. Now, there is a provision that if the supplier has not paid the tax or not submitted the return, then I will not get the input tax credit. Now, my lord, from my side, I have paid the tax. He was a registered dealer, and he has issued the tax invoice also. Now, in spite of that, the provision is that if he doesn't pay, I don't have the control on the supplier to pay the taxes. Now, similar matters, my lord, came up about 5 high courts of this country, my lord. All the high courts have set aside the demand on the ground that the department must verify that whether there was a collusion and fraud with the petitioner, with the supplier and the purchaser. And if there was no collusion, then, my lord, the demand cannot be raised. In one of the judgment of the Calcutta High Court, my lord, the matter from single bench went to division bench, and SLP was filed, my lord. SLP has also been dismissed.
Will issue notice.
My lord, my demand notice has been issued. No coercive measures may be taken, my lord, because the Calcutta High Court decision, the SLP has also been dismissed. And
Mr. Dr. Ashok Chara, senior counsel, assisted by
And
Dr. Learned counsel for the petition. Issue notice. You have it?
Yes, may I please your lordship, my senior is on leave today. Mr. Asikal.
SCKL. Mr. SCKL, Leonard. CGC.
Yes, GST.
Leonard standing counsel, yes.
Demand, data demand.
Affairs for respondent,
All the respondents.
performer respondent.
One performer responded, they brought that.
Commissioner of State Taxes,
Yes, please.
1, 1 and 3. And State of Assam Finance,
Finally, the petition department.
you are Mr.
H. Burwa.
H. Barwal and standing counsel, Finance
Not
and
pending
Taxation.
council, my lord. Only council.
Learned counsel. Appears for the respond number 2, 4, and 5, correct?
I think, my lord.
Yeah, for three.
Five, yes, ma'am.
5. 6, you take steps.
My lord.
Petitioner takes steps for service of notice. On respond, pro forma respond number 6, by registered proceeding within 1 week. List of the forwards, till the next implementation, no pursuit steps be taken against.
In pursuant to the notice dated 9/11/2023, my lord.
In person, the notice dated
9/11/2023.
9/11/2000.
I'm obliged. my lord.
M6.
My lord, we are assailing the virus of the rules, my lord. The sense it, at this stage, Lordship may like to issue notice, my lord. And in case they come up with the advertisement, in that case, my lord, we may be given the liberty to approach your lordship. As of now.
That is open to you. Yes. Third KL Jordan and the senior counsel assisted by Mr. RM Dekli for the petitioner. Issue notice. Majumdar, you have 9. Mr. R. Majumdar, Leonard. Starting counsel,
Sending council.
school education
Department of School
department
Education.
appears for the
Respondents.
1, 2. 1, 2, 3, 4, my lord.
how about 5?
I think 5 also is a government entity only, they can take.
Appears on behalf of all respondents. Notice and respondents are complete. Respondents are to file their affidavits. List of the forwards.
4 weeks.
7. Only WBC today, the all WBCs.
May I please?
Yes, Sarah.
Here, the rule, my lord, has been selected under this and the advertisement, my lord, issued by the BTC, my lord.
Which advertisement?
Advertisement, my lord, is page 94, my lord. My lord, earlier rule, my lord, does not permit to issue this kind of advertisement, my lord. My lord, present rule also does not permit, my lord. Whether they have adopted the rules of the, my lord, notified by the government of the repealing the earlier rule.
Which rule?
Earlier, my lord, is governed in respect of the, my lord, Mondal, my lord, training. It is a pre-recruitment training, my lord. Rule is, my lord, is page 5 copies, my lord, page 23 onwards, my lord. It's the earlier rule, my lord. Rule is, my lord, the rules may be called, my lord, Assam Sovereign Settlement Training Center rules, my lord. In case of Mondal, my lord, required to go for 6-month training, my lord. Prior to, my lord, the pre-qualification training, my lord. So after who has the certificate, they can apply for the post of Mondal, my lord. But in here, my lord, they have issued without the specific post, my lord, for recruitment, my lord, up to 2026, my lord, which is not permissible. And as per this new rule, my lord, the prescribed qualification is, my lord, BA with 50%, having 50% mark in mathematics, geography, and statistics. So that is under select, my lord. This is for the post of Mondal, it is, my lord, high qualification is not at all required, my lord. What is the objective sought to be achieved by the, my lord, this prescribed qualification, my lord. Earlier it was only metric pass.
Already published.
Now by new rule, it is bringing, my lord, 50 BA with 50% marks in these 3 subjects, my lord. Otherwise, it is not eligible for apply, my lord. Let's may come to the new rule, my lord, page rule 8, my lord. Page, my lord, 83, my lord. The academic qualification. The lordship got it, page 83. The minimum requisite academic qualification of a candidate for direct recruitment to any cadre in the service shall be prescribed by the governor from time as per Schedule 2. My lord, Schedule 2 is, my lord, page 91. Now the Lat Mondal has been, my lord, nomenclature as, my lord, land record assistant, my lord. Now by the new rule, my lord. That is a qualification, my lord.
Graduate from recognized university, Lordship got it, serial number 4, in qualification middle, bottom. Graduate from a recognized university in any discipline with a minimum of 50% marks, mathematics or statistics or geography in higher secondary level or graduate, either graduate or higher secondary level. He has to got 50% mark in this one of the subjects, my lord. That, my lord, not required at all, my lord.
What do you think?
Even my lord, APS,
Okay,
SCS,
how
my
to
lord, I,
How do we? Anyway, we can issue notice, but then how do we stop the advertisement?
If I get a two notice, but in the meantime, we have time, I want to file everything.
Yes, yeah.
How about the interim?
Interim, my lord, that it is the,
Consider
my
on
lord,
the
that,
next day.
my lord, the area, my lord, service rule, my lord, that was
We'll
not.
consider the interim of the notices also.
Not.
Yes, sir.
in case of my lord, BTC advertisement, that may be my lord, outcome of the, my lord, this petition, my lord,
No,
and
let
the
us-
selection process.
How many respondents are there?
4, my lord.
PTC you are appearing and Henry,
I am appearing, Your Honor.
you are
And they have a response number 3, 4, and 5. Lord.
Oh, sorry, 5, my lord. 3, 4, and 5, as per state of Assam, 1 to BTC.
you are appearing for 1 and 2.
1 and 2.
But M. Saranil and also for the petition. Issue notice. MS P. Das,
On behalf of P Nayak.
appearing on behalf of Mr.
P Nayak.
T. Nayak.
No.
Standing counsel between appears for respondent
I have looking,
1 and 2.
not Nair.
And Mr. J. Hendrik Leonard. Standing counsel,
Revenue, Lord.
revenue appears for the respondents, 3.5.
3.5.
Notice on respondents are complete. Respondents are allowed to file affidavits. This the matter after 4 weeks. Prayer for interim shall be considered on the next sitting of the.
But in case of BTC, lordship may consider it because
That is an advertisement of May 2023.
my lord.
So on the next.
Because why, my lord? According to new rule, if they have adopted, my lord, first selection, they go for training.
Let us see. what
But
they-
by this, they have only selection process initiated only for training,
Let us see what they come with.
my lord.
Deeply obliged.
My lord, lordship may fix a date, my lord.
You are not there.
My lord. Because prayer for interim is to be considered, my lord, until my lord, unless fixed at that, it may not be listed also, my lord.
29th January.
Highly blessed, my lord.
Item 8 for admission.
The matter may be passed over for timing also.
Why?
8 and item number 9 also. Item 10.
My lord, this is so much of PIL, man, a very tragic incident, my lord. Then mother committed suicide after killing 2 of her son. One is 2 years, one is only 15 years old. 15 days old, my lord.
15 days.
So, and that, my lord, this PIL was registered by Somoto, and they were asked to file, the district administration were asked to file an affidavit and stating the reasons. And my lord, more particularly, that person is from the missing autonomous council area. So there are so many government, my lord, beneficiary, government scheme are allotted to the, my lord, that scheme, the missing area. Why this, my lord, schemes are not these people? That's why, my lord, the presence of the missing, there is a party, the missing autonomous council, the chairman was made party. So whether they are appearing or not, I don't know, my lord. So there is a affidavit from the deputy commissioner stating that because of the extreme poverty or also the mental imbalance, he has committed suicide.
So there should be something, she's not receiving the scheme.
Exactly, that, my lord, the missing autonomous council is the best person because they are nowadays government of Assam. That is, there are so many development scheme regarding the council, my lord.
Notice has gone to them.
Notice, my lord, it was issued, my lord, very recently. It was engaged me, my lord, in this case. Earlier, my lord, Mr. Honorable Justice Nair was there. So, my lord, whether notices are or not, my lord, my lord, I am not been able to find it out, my lord.
Where the respondent?
There is a standing council probably.
Yes, it's.
No. R3 is the missing. No notice has gone.
Respond number 3.
Yeah. Awesome.
Probably, my lord, my learned fan, there's a standing council, my lord.
I am on behalf of
You are appearing?
For respond number 3, he will appear.
Yes.
So,
What do you have to say?
For the first time, he is appearing.
for the first time. So, my lord, I'll ask the registry to have a copy, my lord, and after vacation, my lord, let him take time, my lord.
But Mr. TJ Mandal, senior counsel, or standing counsel, Guwahati High Court. Stop. The district commissioner, Lakhimpur, as well affidavit. Stop. Para. Mr. D. Gogoi Leonard, counsel enters appearance on behalf of the respond number 3. And raise for how much time you require? 2 weeks time. Will it be sufficient?
So, let it be after
How
vacation.
many schemes are there? You'll have to file. Raise for 4 weeks time.
My lord.
To file affidavit.
Well,
Raised on 2nd February.
in the affidavit, we have indicated some of the benefits have been given to the family. Well, I'll serve a copy to him. He will also get the instructions apart from this, what further can be given to the family. Otherwise,
No,
otherwise, this we have already given
Victim has already gone.
No.
Such type of incident never should not be happen in future. That is the
to other person.
Registry is
Go ahead.
directed to furnish a copy of the present PL to Learners Council appearing for
mine.
responsibility.
And standing.
SCMEC.
Registry was also directed to reflect the name of Mr. S. Godago, Learners Standing Council, missing authorized council in the constitution.
Item 12.
I have a caveat in this matter. I have a caveat in this matter.
But Mr. A.C. Borgora, and senior counsel for the cabinet. Yes, Mr. Das.
Yes. My lord, we agree by the judgment passed by the Honorable Single Judge. We have been reverted to the post of environmental scientist. We were the assistant environmental scientist in the Department of Pollution Control Board. We have been serving in the department. Thereafter, we have been reverted back to the post of environmental scientist. We were assistant environmental scientists, reverted back to the post of environmental scientist. We are agreed by that and we were before the learned single judge. So
Your assistant environmental
scientist
reverted back to
we were assistant environmental scientists in first, then we were promoted to the post of environmental scientist. By an order passed by the department, we are again reverted back to the post of assistant environmental scientist. So we were before the honorable single judge. Now, 3 documents are very important in this case. One is page 44. Your lordship kindly note down page 44, 45, and 46. 3 documents which are important. My lord will quickly note down these 3 documents. Kindly see page 42. Just a background, 42, kindly see. Page 42. My entry into the department was scientific assistant by page 42. Kindly see, my lord. Or appointed as scientific assistant under so and so. Lordship got it? Now kindly see serial number 2 and 3. Kindly note down it is serial number 2 is appellant number 1. Serial number 3 is appellant number 2. Now kindly turn to page 43. This is by another order 27th of November 1995. This is appellant number 3. This is Manoj Porua at page 43. Lordship got it?
Yeah.
Now this page is very important, page number 44. Now, the Pollution Control Board decided to redesignate it, the post which they were holding. And kindly see how redesignation was made. Board analyst was redesignated as senior environmental scientist, deputy analyst, executive environmental scientist, assistant analyst is assistant executive environmental scientist, 4 is chemist, assistant environmental scientist. So we were chemist. My lord will kindly note down, we were holding a degree of BSc. That's very, very important. BSc. Now, this is what they decided to redesignate the post. Now, in between serial number 3 and 4, they decided to create a post of environmental scientist. Now, how we will get it? Kindly see down below. In between the rank of assistant environmental scientist and assistant executive environmental scientist, the board has approved a post of environmental scientist for direct recruitment of science postgraduate as well as promotion of chemist with BSc degree, which is presently not held by any one and therefore not shown in the table. Now the board decided to create a post. That post is environmental scientist. Note in the below what they have said, a direct recruitment, MSc is required. But for promotees who are holding the post, BSc is only requirement is BSc. That's why your lordship will kindly note down 44 is important. Now lordship will note down, we are BSc. We were chemist, redesignated. Now they decided to create a post, namely environmental scientist. So our qualification is only to the extent of BSc because we are not direct recruit. Direct recruit is MSc is required. Now kindly turn to page 45. 23rd of September, subject to approval of the board, the post of assistant environmental scientists in the board are upgraded to the level of environmental scientist with immediate effect. Consequent to that, the following assistant environmental scientists are upgraded to the level of environmental scientists. The pay and other promotional benefit will accrue to this scientist with retroactive effect only after approval of upgradation by the board. Now, what they decided to upgrade the post from assistant environmental scientist to environmental scientist. And the board decided these are the person which we are going to upgrade. These are 7 numbers. Kindly note at serial number 1 is the appellant number 1. At serial number 2 is appellant number 2. And serial number 4 is appellant number 3. Kindly put a note that serial number 6 is private respondent. 5, 6, 7 are all private respondent in this case. Now, 46. Now, your lordship will kindly see the wording at page 45 once again. I'll just trouble at 45 once again. It is saying the pay and promotional benefit. This line is very important at page 45. Your lordship will kindly note down this line. The pay and other promotional benefit will accrue to this scientist with retrospective effect only after approval of upgradation by the board. What I understand, meaning thereby, there has to be an approval by the board, but your pay and protection will be from this date, 23rd of September 2013. So this is very important, your lordship will note that. Now, kindly turn to page 46. This is 12 August. It was placed before the board. Now the board approves. 12th of August 2014. Lordship got it? In pursuant to the decision taken in 96th board meeting under agenda item number 5, 4 posts of assistant environmental scientists are upgraded to the level of environmental scientist, and the following 4 senior most assistant environmental scientists are allowed to hold the upgraded post of environmental scientist with effect from the date of their joining as shown against their names. The pay, Lordship will kindly note this line. The pay and other promotional benefit will accrue to them with effect the date of their joining as per the board's order dated 23/9/2013. That is page 45. Now, out of 7, Lordship had noticed down at page 45, there is a 7%. Out of that, as per seniority, if you see serial number 1, 2, 3, 4, serial number 1 is the appellant number 1, serial number 2 is appellant number 2, and serial number 4 is appellant number 3. And down below, in view of the board decision as referred above, as para, the post held by following personnel shall continue to be the level of assistant environmental scientist as the designation shall be. So out of 7, they considered only 4. Rest will remain as assistant environmental scientist. Now kindly note down the last word, last sentence, last 2 lines at page 46. Consequent upon the board decision on the matter, the office order issued by the board dated 23rd of September 2013 stands annulled. Why I'm showing it? This is the contention of the other side. If it is annulled, totally it is annulled so far as 45 is concerned. 45 is concerned. So kindly note down this, why they said this. Now, my lord, this we have been working with the department. Suddenly we received a so-called notice. 3 different so-called notice. Contention is more or less same at page 47. Lordship will kindly note down at page 47, 48 and 49. 47, 48 and 49. What they are saying, my lord, kindly see 47 first. Pollution Control Board, Assam employees, Regulation 2012, wide recruitment, first 47, and promotion under Regulation 9 and C, fixed qualification, experience and promotion of employees of laboratory and scientific service. As per above mentioned regulation, all those assistant environmental scientists have completed minimum 5 years of service in the board as AEC chemist shall be brought under the category of environmental scientists along with the post, provided they acquired postgraduate qualification within 5 years of their service in discipline stated in clause A above. All of you are BSc degree holder, please let this board know whether you have applied permission to the board for pursuing the postgraduate degree at any recognized university or not. Your reply should reach the undersigned so and so. So now your lordship, what has happened? 2012, lordship will kindly, this is very pertinent. 2012, a regulation has been framed by the board. 2012. Now that regulation has to be approved. Now that approval is only in 2014. It is clearly, I'll show my, that regulation, unless you don't approve it, that will not be applicable. I'll show it. It has to be approved. Once it is approved, it is applicable. Now this regulation which came into force was at page, kindly note down at page 54. See page 54. Lordship got it? Page 54. This is the approval. That is 24th of February 2014.
Yes.
This is the date where, my lord, it was approved. This is the date of approval of the regulation. 24th of February 2014. So this is clear, my lord. So they made the regulation in 2012, but it was approved in 2000. Kindly see the first 2 lines of page 54. In inviting to a reference on the subject letter cited above, direct to convey the approval of the government for the draft pollution control board, Assam Employee Service Regulation 2000, subject to following condition. So this is 2012. The regulation was framed by them. It's a draft regulation. which was approved by them in 2014. Now we go back to page 47. Now what it says, my lord, a show cause was issued to us. Now in the show cause, they said we've made a regulation. In the regulation, there are certain condition of service, like qualification, which has been spelled out 9A to 9C. So in 9A, what it says, if your lordship kindly see the regulation, kindly see the copy. This will make clear. I'll just connect it. Where is that? Kindly see the regulation. Lordship got it? Regulation. Pollution Control Board, Assam Employees Service Regulation 2012, approved in 2014. Now, if you see this regulation, I'll just read 1, 2, 3 of 1. This regulation shall be called Pollution Control Board, Assam Employees Service Regulation 2012 at page 1, my lord. This is Roman 2. This regulation shall come into force with effect from the date of notification to be made by the government of Assam on its approval. So, your lordship, I have shown 2014 approval was given. 2014. It is, lordship will kindly note down, this regulation is not written anywhere. It will be have a meaning of retrospective. It is always a process, unless it is not spelled out. Two things I will show: saving and repeal and saving clause is also there. Now, kindly see 3. This regulation shall be applicable to all whole-time regular employees of the board, whether appointed on a time scale of pay or on a fixed monthly pay or salary appointed either before or after this regulation came into force. This also, they have taken a point. So, you are the employees of the board. So, 3 is also equally liable for you. We said 3 is liable. Yes, we fall under this regulation. But you have to see page 44, 45. That's why I'm pressing hard on that. Whether my educational qualification, that's the point, my lord. That's, my lord, your lordship will kindly note down 2 consideration point here. The main point. First point is whether our qualification, whether MSc is required or not. Regulation now, if you see 9A, kindly see 9A.
When was this regulation notified?
2014 it was framed. It was made in 2012. It says unless it had to be approved. Approval is 2014. Now, if your lordship just recollect, your lordship seen that page 44 and 45. 44 and 45. Your lordship will keep one hand in the regulation here and see page 44 and 45 once again, my lord. See 44 and 45. And then I will take to the condition of service. See page 44, my lord. Page 44, which I read, I said these 3 documents are important. Last line, in between the rank of so and so, has approved a post of environmental scientist for direct recruitment of science graduate as well as promotion of chemists with BSc degree. Now this, your lordship will kindly say 7th of April 2012. By that time, draft regulation has been framed. It has not been approved. So my degree is to the extent of BSc, only insofar promotees are concerned. If you see 45, the order 23rd September 2013. Till then, my lord, the regulation which is framed by the government, by the board, my lord, that has not been approved. Approved is only 2014. So if 2013 is to be taken, then this 2 line is important. The pay and other promotional benefit will accrue to this scientist with retrospective effect only after approval of upgradation by the board. So maybe board may approve in 2014 or 2016, let us say, but your effect will be retrospective from the date of this 23rd of September 2013. So what our argument is before this honorable court is that whether my qualification will be covered, condition of service is to the extent that MSc is required or BSc is required. So my argument before your lordship is that BSc is only requirement because my requirement is also backed by 44 and 45. At that time, the board is only mere approval has to be granted. So now if you see the regulation, kindly see the regulation at 9 is page 9. Kindly see page 9. If you see page 8, kindly see B. Kindly see B, laboratory and scientist service. If you see number 12, it's an environmental scientist. These are the posts, environmental scientists, by the virtue of this regulation. Because your lordship just recollect, environmental scientist post has been created in page 44 by the government in between 3 and 4. And how degree has to be obtained, that has been promotees and direct recruitment. This is by regulation. They framed it and they said these are the. Now, if you see at page 9, Roman 3, see Roman 3, my lord. Qualification, experience, promotion of employees of laboratory and scientific service. A is important. For recruitment to the cadre of environmental scientist, the minimum qualification shall be master degree. Lordship got it? Master degree in chemical, biological, life or environmental science from any Indian or foreign university or institution recognized by the Government of India. Kindly see B, the promotional criteria for assistant environmental scientist and environmental scientist to the higher cadre shall be as per table 3 in appendix 3. Appendix 3 will be, let us see page 34, my lord. 34. Let us go simultaneously, my lord. Page 34 is table 3, appendix 3 at page 34. 34. Lordship got it?
Yes.
See 6, serial number 6. It is environmental scientist. Kindly see is do. Do means if you go to educational qualification in MSc. This is what they're saying. MSc is required. Now you please come to again page 10. C. This 3 clause. Again come to page 10, clause C. All those AEC, assistant environmental scientists of the board who possess the minimum education qualification for environmental scientists as stipulated in clause A above or have completed a minimum of 5 years of service in the board as AEC or chemist shall be brought under the category of ES along with the post provided that they acquire postgraduate qualification with 5 years of their service in discipline stated in clause A and A above. So what it says, my lord, C has been given a particular the benefit to those employees who are working as assistant environmental scientists. You will be promoted, qualifying, subject to condition, qualifying of 5 years. Then we give the benefit to you within 5 years from that day, from the date of promotion, within 5 years you complete that MSc. That benefit is given under C because they have been working. So this is what the regulation says. Now, these are the qualification which has been laid down. Now, whether this qualification which has been laid down, which is approved in 2014, the point here is whether it is applicable to the appellant or not. Whether they should get the benefit of the before the regulation was framed, approved, or whether after the regulation they will have to do this under C. This is our question before this honorable court. Number 1, my lord. My submission to this affair will be, kindly see, my lord, there are 2 arguments which I will try to make it. Why it is not applicable? Because 44, if your lordship kindly see, 44 is of 2012. In between 3 and 4, they decided to make a particular, they create a particular post, namely the environmental scientist. For that, degree has been specified. This is of 2012. 2013, at page 45, they decided to upgrade the post of assistant environmental scientist to environmental scientist, where the consideration 7 number of person who are working. Now at page 46, they decided that yes, but they have been promoted. They have taken that these are the percent which out of 7 we decided 4, and which the appellants are before the appellants names appears. But kindly see the word pay and other promotional benefit will only from the date where this particular order, office order was issued. Kindly see at page 45. This is the whole case, my lord. Page 46. Page 46. The pay and other promotional benefit will accrue to them with effect from date of joining as per board's order dated 23/9/2013. If that be the case, my lord, I could have, suppose, let us take for an example, my lord. Let us take for an example, my lord, myself and my learned friend. In 2012, these names appears at page 45. All 7 names appears. Now, out of 7, my lord, 4 has been picked up where we are. Now, there is a resolution taken. Office order says these 4%, yes, they are promoted, they are upgraded, but their particular pay and other promotional benefit will be retrospective effect. Now, somebody who now is in the name below me, his particular is placed after 2014. Then, of course, yes, that requirement is mandatory. It is placed after the regulation. Here it is before the regulation all has taken place. So where is a question of the regulation to be enforced? In fact, my lord, they have taken stand by the board in one of the writ petition which was filed by some of the, I'll show that, which they have supported. They said, yes, it is retrospective effect, we have given the benefit to them. How they can now take a stand? So no, what you have to do it, your MSc is required now. This is what is the point. Second, my lord, will kindly see the regulation again. See the regulation again, my lord. Chapter 8. Chapter 8, page 31. Now, page 52. This is regulation 52. Sorry, regulation 52, page 31 down below. Repeal and saving. Rules and orders issued by Government of Assam correspond to regulation in force immediately before commencement regulations and no longer be applicable with effect from the date on which regulation came into force. All the regulation adopted by board corresponding to the regulation and in force immediately before the commencement shall no longer be applicable effect from the date are adopted by board, and to the extent this regulation will come into force, date of adoption of the board. B is important. Notwithstanding the provision of regulation 51, all orders made or action taken under any rule, regulation or resolution of the board prior to commencement of this regulation in respect of matters relating to condition of service of the employees of the board shall be deemed to have been validly made or taken under the corresponding provision of this regulation shall be treated as valid. So this what I'm saying, it has been saved. Any orders, resolution taken by board, that is saved. So my case is that when it is saved, then it will get a retrospective effect from 2013. It is only adopted in 2014. So conditional service, so far as the degree is concerned, is not required. This is what I'm trying to impress your lordship on this saving clause. Now, how a decision has been taken by the board, kindly see, my lord. This is the impugn order, how they have reverted back to me at page 62. This is the impugn. In the lordship, this is the impugn order. See, my lord, 1, so 05, that this is the appellant. This is appellant, no? This is appellant. In the interest of so and so board service as per recommendation of board as per agenda of board meeting and also considering the view of standing council submitted by letter, see so and so is reverted back to the rank of assistant environmental scientist with immediate effect. This is one. Number two is again another appellant, Kormojit Nath, same. Now last, number three is retired. Number three is retired. Number four is another Manoj Porwa. The same David. Now, decision which they have taken is at page 63 is the minutes. Page 63, 104 board by meeting. 104.8, that page 67. Kindly see page 67. Agenda item number 104.8. What you got it? Agenda of upgradation of 4 number of assistant environmental scientists on environmental scientists, namely C. Ranjan Bodloi, Kamarjit Nath, Jibon Sarkar, he retired. Manoj Borua, by regulation made by the board in his 96th board meeting held on 5/8/2014 was discussed in detail. As per the provision of the Pollution Control Board, so and so, the promoted scientists were required to obtain master degree within 5 years of promotion. All the aforesaid scientists who were promoted dated 12/8/2014 failed to acquire a master degree within the stipulated period. The view of the standing council of board in the matter submitted his letter to member secretary was perused by the board. The board resolved the provision of acquiring master degree within a period of 5 years is included in the Pollution Control Board 2012, and as such provision should be strictly honored. The board resolved that the aforesaid 4 scientists who could not complete master degree with stipulated 5 years would be reverted back to the previous post with immediate effect. This is a resolution taken by the board. In pursuance to the resolution we taken, this impugn order has been passed. We put to challenge. These are the basic points we have put to challenge. How the learned singles has dealt this matter, that I will just show at page 208. Page 208, kindly see. Coming to the claim of the petitioner that they were promoted from the post of environmental scientist, assistant environmental scientist to a promotion post of environmental scientist before the regulation 2012, before the 2012 regulation came into force. In this regard, learned counsel petitioner already heavily relied on the statement made by respondent number 2 and 3. 2 and 3 is the board. In their affidavit in opposition file in connection with WPC 8263 of 2022, which is referred to above and thereafter not repeated again. Why, my lord? I will just tell your lordship that there was few cases which was filed by the department. Somebody was promoted, double promotion. This was led to challenging the entire this promotion. And these are stand which has been taken. Stand taken, whether retrospective or prospective. Kindly see this, the affidavit. Ask on the other side. I will call for the records, my lord, for this affidavit. Just prima facie, I am showing it. What does it mean? Yeah, other side, give it other side. Yeah, other side, then give it one copy. One side. Hey, to detail. We did it. This is, kindly see page 63, my lord. See page 63. Why I am showing it? This is what the learned single judge at page 44. Page 63. Paragraph 20. See para 20. See down below. There is a writ petition number 5061. Rubiul Haq versus State of Assam and others in Guwahati High Court. The promotion of respondent WPC 5061, namely Karuna Thakuri and Hiten Sharma, were done by so and so. Prior to the Pollution Control Board Assam, regulation to the came into force with effect from 24th of February 2014. On receipt of the approval of the government under section 1(2) of the state regulation. This regulation does not have any provision for the implementation with retrospective effect. Lordship, kindly note down, which I said. Rest of the respondent of the state writ, namely Ranjan Bodloi, so and so, along were upgraded to the post of environmental scientist subject to the approval in the board. And accordingly, they joined as environmental scientists on 23/9/2013. Subsequently, the board in its 96 meeting approved the upgradation of so and so only with effect from the date of joining. That is from 23/9/2013, prior to the date of the Pollution Control Board Assam 2000 came into force with effect from 24th of February 2014. So they themselves have stated in their affidavit, their promotion, pay and allowance, what has been taken prior to the regulation was framed. Now kindly see paragraph 45. The 2012 paragraph 45 at 208 of the judgment. 208 of the judgment. This is what I just want to show the stand of the board. Now kindly see 208 at paragraph 45. The 2012 regulation came into force after its approval by the government, was conveyed by the Environment and Forest Department communication dated 24/2/2014. However, the 96 board of meeting of so and so held on 5/8/2014. In the said meeting, a resolution as per resolution taken in respect, agenda number 5, upgradation of Ranjan Bodloy 1, Kamarjit Nath 2, Jiban Sarkar, Manoj Borua, being 4 senior most personnel were approved. The PCB in his 96 board meeting failed to consider, my lord will kindly say, I think 96 board meeting was not brought to the court. What the court is saying, the 96, it was board meeting for resolution, it is what? No, that. This agenda is not there. Huh? So now my lord will kindly see the PCBA in his 96 board meeting failed to consider the provision of 2012 regulation, including higher education prescribed for the post of environmental scientist. The learned single judge now is trying, my lord, to make out a case with great respect, saying that 96 board meeting, they decided they have bypassed that regulation of 2014. Subsequent, why? 2016, my lord, they realized, and 2016 they have issued a so-called notice because they were aware of it, that this regulation is not applicable so far as the appellants are concerned. Appellants are concerned, they were aware of it. That's why, my lord, so-cause was given 2016. My promotion, which taken place 2014, but with effect from 2013. Now kindly see the next 46. The 2012 regulation has come into force after its approval by the government, was conveyed by the Environmental Forest Department by communication dated 24/2/2014. Therefore, the court is inclined to hold resolution taken in 96 board of meeting held on so and so, thereby approving the upgradation of 4 senior most person, namely so and so, without requiring the said 4 person, including the petitioner, to obtain the prescribed education within 5 years was done in violation of the educational prescribed under 93A to 93C, which I have shown my condition of service. It reiterated even the cost of so and so. Now, this is what, my lord, the finding. Para 47, 48, kindly see. The court is of the considered opinion that PCBA was bound by 2012 regulation, which has come into force on 24/2/2014, when the government granted approval for the same. It could not be shown on 5/8/2014 when 96 board meeting was held. It has been vested part to wish away the essential requirement of petitioner to obtain the essential educational qualification of master degree in so and so or so and so 93C of 2012 within 5 years of the service as environmental scientist. Therefore, the approval granted in respect of upgradation of the petitioner, another person held to be not in accordance with requirement prescription of 2012 regulation. Therefore, such approval cannot create an indicible right in favor of the petitioner. This is what the finding, and paragraph 51 says that there can be invocation of the relaxation by the government. It is up to the government. It is up to the government. Relaxation, invocation, because there is a clause of relaxation. We are not on relaxation. Our is the right. Now, while moving this application, my lord, this has to be examined by the court. Now, while moving this application, there was some interim order which was passed at page 89. Kindly see, my lord. 89. Kindly see 89. 89 at 9/9/2022. Nine 2022 is the order of this court while moving this application. Kindly turn to page 91. The last paragraph. On perusal of the contents of writ petition, seen the petitioner promotion, the post of environmental scientist wide order dated 23/9/2000 was subject to approval of Pollution Control Board, and the board approved the same wide order dated 12/8/2014 with effect from 23/9/2013. Regulation 2012 was approved by the state government on 24/2/2014. After hearing this, that 3 posts from which the petition have been reverted should not be filled up till the next date. So what I pray before your lordship that already we have been reverted. So let this 3 posts, even when it has not been filled up, till you decide, my lord, let it be kept in abeyance, that 3 posts, as my lord directed by the learned single judge. And your lordship will examine this matter, my lord. These are important points, whether one should get the benefit of retrospective or prospective, whether my qualification is required. This, my lordship will issue a notice and intimate these 3 posts should be like order of the learned. That's why I annexed that. But while deciding, because they any moment, my lord, my post may be filled up. That's the whole difficulty. I just pray lordship will issue a notice, and in the meantime, this as directed initially moving the matter, 3 posts should be kept vacant, my lord. The post of environmental scientist. This because they have created, they have upgraded. I have seen that there were 3 posts, 7, 3, 10. So 3 posts, my lord, let them be kept, my 3 posts. You can't take a different stand. Board is taking a different stand. This is my humble submission to lordship.
Lordship, I will not take even 1 foot of what my learned friend has taken time.
I have to
The question-
take time because I'm the
Right,
petitioner.
moved.
Yes, I have the
So
excellent.
the
in this
first
case.
thing first, the initial single judge's interim order, learned single judge interim order was expert. Thereafter, we have sailed through this turbulent weather. And I am here to defend the judgment of the Honorable learned single judge, my lord, where I am affected. I am in the, lordship has seen the hierarchy from Eastern Environment to Environment Officer, Scientist. I have completed almost 9.5 years of service without a promotion. Because the posts were allowed to be held by undeserving persons like the appellant who, under the statute, do not have the requisite educational qualification. Everything that has been done by way of notification or by way of board resolution earlier, prior to the coming into effect of the regulation 2012, which came into effect in 2014, my lord, the statutory requirements of having a master degree, my lord, does not evaporate or my lord, all these notifications cannot override a condition which mandates that one has to be a master degree holder. Lordship, kindly have a look at page 46. Page 46. See the manner in which their initial appointment was done. Page 46. This is, my lord, dated 12th of August 14. One important word. Pursuant to the decision taken of 96 board meeting, learned single judge had told that this board meeting decision was not correct because it tends to override the Malawi statutory requirement. That was the view of the learned single judge. Even disorder, decision taken 96 board meeting was for what? For the post of environment science are upgraded to the level of environmental scientist, whether that could have been done or not. And following, 4 senior most assistant environment scientists are allowed to hold upgraded post. They were just allowed to hold chairs. This is not a promotion, let alone a regular promotion. Why this holding of charge of next level post of ES is because these persons did not have master degree on that date. So therefore, in the exercise of service, they were allowed to hold charge, my lord. And moreover, kindly have a look at this. This could not have been promotion from AES in view of the provisions of, my lord, 7 Roman 5 at page 6 of the regulation. Here, lordship will also get in here at page 50. It has started at page 55. Yes. Page 57, lordship. Method of recruitment. Roman 4, this is relevant. There are, my lord, first there are the various methods of recruitment. Clause 7(1). One is direct recruitment, one is promotion, one by way of deputation, one on compassionate ground, one on contract. Depending on the exigencies of service, people can be brought on contractual basis also. Roman 4. Number of vacancies under the various cadres and their percentage for direct recruitment and promotion from the next cadre shall be decided by the board authority. However, for ready reference, such provisions are incorporated in column 5 at table 1. Similarly, promotion avenues from lower to higher posts are also shown in table in appendix 2. Then, my lord, percentage mentioned in sub-regulation 4, next clause, means percentage of total number of vacancies that arises in a calendar year. If the required number of vacancies meant for promotion, direct recruit cannot be filled up by promotion or by direct recruitment, for want of such candidates, normally such vacancies are to be carried forward to the next calendar year. Then, my lord, this your lordship will have to read with, my lord, table 1, appendix 1. Yeah. What is it? Nothing. It's not here. Page 32. In the regulation, page 32. Right? Here, lordship will find appendix 1 and appendix 2. There are posts, my lord, existing new and filled up, upgradation. Some are from the, my lord, promotional avenues and some are directs, right? Here, appendix 1, environmental scientist, new posts. 7, total posts, 10. 4 for direct recruit, 3 for promotion. So nothing of this, my lord, promotional and direct recruitment posts, your lordship will find nowhere there in page 46. And moreover, all 4 could not have been by way of promotion. In fact, this was not a promotional order. This was an order allowing them to hold charge on both counts. And moreover, there has to be a selection for any promotion. If it is their case that they have earned a promotion, it has to be by way of a selection. Provision to control. No. One has to earn it by way of selection. Any more question? Regulation 9, which your lordship will find at page 59. Page 59. recruitment and promotion, right? One. Page 59 of the regulation, page 59 of the memo of appeal, regulation number 9, recruitment and promotion, subject to suitability as may be decided by the selection committee and by appointing authority as set forth in regulation 10, and also subject to processing such qualification and experience as prescribed under table 2 to table 7 in appendix so and so under regulation 7.4, appointment by direct or promotion to the following categories of posts shall be made by the authority on the basis of select list. There has to be a select list, both for direct recruits or for promotees. Where is that select list? They cannot get a promotion by way of a bounty. They must earn it. One, there was no select list. Number two, whatever notifications were issued prior to coming into being of the act, I'm sorry, regulation, those could not have overridden the mandatory statutory requirement of one having a MSc degree education minimum. And so far as this affidavit is concerned, my lord, talking about this was not part of the records, part of the pleadings before the learned single judge. This is an affidavit they have suddenly put before your lordship. And
Not a reference.
I am being told this case has been withdrawn by the jurisdiction. I am just pointing it out, whether ultimately your lordship takes into account. So therefore, they are already reverted. But the question is, I am stuck up even after 10 years of service. Now a process is being taken. Not only they have been reverted, they stand reverted. They are not out of employment. They are not out of employment. They win the writ appeal, they will be restored. But this appeal will be pending for 1 year, 2 years, my lord. And I am stuck up. I am in the queue, my lord. I am an MSc. I am a lady, I am MSc. So therefore, one more thing, kindly see the provision. Provision at my lord page 61. Kindly see what is the statutory mandatory requirement. This cannot be undone by any board resolution. Board resolution may be wrong, but the statutory provisions remain intact until and unless such statute is overruled by a court of law, declared vitiated. Lordship, C. It is 9, my lord. I am reading from page 60. Qualification, experience, and promotion of employees of laboratory and scientific service. Below, 60, below. For recruitment to the cadre environment scientist, the minimum qualification shall, the word is shall, mandatory, be master's degree in chemical, biological, life, or environmental sciences from any Indian or foreign university as recognized. Whether by way of direct recruitment or by way of promotion, one has to be a master degree holder. Then, lordship may come to next page, C. This is the condition. All those AES of the board, assistant environmental scientist, of the board who possess the minimum educational qualification for ES as stipulated in clause A above, that is master degree I have read, or here, in both cases, have completed 5 years of service in the board of AES like them, or chemist. Here the word is also chemist. Chemist. Like the appellants who have completed 5 years of service in the board as AES or chemist shall be brought under the category of ES along with the post. That's how they were brought. Provided, this word provided is very important, and this is the statutory requirement, provided that they acquire postgraduate qualification within 5 years of their service in discipline stated. This is a conditional appointment. That all right, you don't have master degree, since you have completed, we give you a chance, you take charge of this post, but provided 5 years time we are giving you, obtain a master degree. Unless they obtain, and they for that. And Lordship will kindly see how they were cautioned repeatedly. Page 47. The first notice given, master degree requires 2 years, suppose 2.5 years. Taking advantage of the COVID and all, they have gone beyond 6 years. Now 9 years. It cannot be bounty, cannot go on like this by blocking others. By blocking others, it cannot go on like that. They are not out of employment. They are in the office today. But in what capacity should be? Should the appellate court entertain this, my lord, appellants enjoying this without having the requisite statutory qualification at my cost? That is the condition. Not that learned single judge initial ex parte order, we are not there. Will automatically be here again after the disposal, and the single judge has rightly said so. That there is a, when there is a statute, you cannot. Kindly see this 12 September notice, page 47, qualification. To all of them, they have not replied to this notice. Or maybe, as all, last paragraph. Or as per the above mentioned regulation, this has quoted regulation 9A and C. This is of 16 after coming into being. Already that regulation came. Then, as all of you are BSc degree holders, please let this board know whether you have applied permission to the board for pursuing postgraduate degree at any recognized university or not. Your reply should reach. Then again, the next page. 48. Again, they were given a second notice. As you have failed to furnish reply against the office order, it is presumed that you have failed to comply with the provision of police. In view of, please note that board will initiate appropriate action in due course. And kindly have a look at page 52. This was their reply. They said, during the course of such discussion, it was also pointed out by the undersigned, one of the appellant, to invoke the power of relaxation as provided under 49 for relaxation of regulation 9(3)(c), page 52. So they, knowing that they could not obtain a master degree in their lifetime, if it is not into 6 years to 9 years, let alone 2 years, they also paid for, and that is exactly what the learned single just granted them. All right. This way done by overriding the statutory provision.
Yes, heard Mr. Didas, the senior counsel. Assisted by Mr. Teacher Probability, and also for the appellants. Stop, admit. What are the respondents here? Forest,
Lordship, I am for forest.
Mr.
I bought it.
I, Butagor, Study Council, Forest and Environment, Affairs for Respondent number 1, Pollution Control. S. Borough, Standing Council, Pollution Control Board. For respondents 2 and 3.
Yeah.
You are appearing for?
Private respondent, final 8.
And Mr. S. Barbara. Senior Counsel, assisted by Mr. M. For the respondent number? Only 8. Then you'll have to take steps.
Oh, yes, we'll take.
Oh, Mr. S. Haq, Counsel, press for respondent number 5. Stop.
Rest we have to take steps.
Appellants to take steps for service of notice on the respondents 4, 6, and 7 by registered post AD within 1 week. List after 4 weeks. Stop. we can't give you an interim order.
No,
Mr.
just
Raj.
3 posts would be kept vacant at page 92.
It
Page
is-
92,
it
there
will
is,
be Subject to the outcome of.
but the
this
3
redevelopment.
post already has been kept vacant by when it was moved before this court. That's why I'm saying let the 3 posts be kept vacant.
Blocking is neither in public interest, my lord.
Any promotion made to the post of environmental scientist, isn't it? Held by to the 3 posts of, held by the appellate.
Blocking is
Shall
not in
be
public interest.
subject to the outcome of this writ appeal.
And my lord, so far as I am concerned, my course of action is open. I may appear in response to my lord advertisement as a direct requisite also, or also promotion. And I believe a promotional committee has also been constituted. There shall not be any bar for me.
They have to come file writ petition. Let them file.
We're not.
Yes.
Got it.
Deeply obliged.
That was, I think,
All right.
20 from supplementary is for admission.
My lord, that yesterday's matter, my lord, today it has come up again, my lord. But the issue important in this matter is, my lord,
Who filed the caveat?
keep it, my lord, my senior counsel, my lord. Respond number 4.
KK Mahandan, the senior counsel. Caveat. Caveat stands discharged.
My lord, the issue involved in this case is, my lord, the appellant was a sitting lessee of this particular fishery, my lord. His term expired on 5/7/23. But see, because of certain exigencies, my lord, the area of the fishery, 80% has been included in the Orang sanctuary. So there remain 20%. For 20%, the government wanted to make the revenue. What will be the revenue under Rule 48 of the rules? They want to assess it, my lord. So it takes some time. So the deputy commissioner passed an order. Sitting lessee, you run it on daily basis. While he was running, the government, the respondent number 2, issued an order cancelling this order, my lord, and allotting it to the private respondent, my respondent number 4, my lord. That's my case. Now I just placed the background of your lordship, my lord. Please come to page 54, my lord, please. There's a writ appeal judgment. Because initially, this fishery was settled with respondent number 4. So ultimately, it is the order passed by the division bench of this honorable court, my lord. The fishery was settled with us, my lord. I just want to show to this page number 54, my lord. Please come to page 54. Kindly see, my lord, this is the present fishery, Bagpuri, and serial number 3, Sieganga fishery. Lordship has seen, my lord, page 454. Respondent number 3 is Sieganga fishery. Lordship has seen, my lord. This is the fishery, my lord. The party involved, he's responsible for in the present case, my lord. So the division bench has passed the order, setting aside his settlement order. It was provided to me. Please come to page number 57, my lord. Annexure 7. Page number 57, paragraph 7. Let me just read, my lord, slowly. The state government thus apparently admitted before the Supreme Court that members of appellant belong to Maimal community, we, my lord, appellant, of Astral Kachar district. Not only this, pursuant to the judgment of the Supreme Court, Deputy Secretary to the Government of Assam, by communication dated 16th June 6, very emphatically directed the Deputy Commissioner not to entertain any dispute in future against the appellant on the ground that its members do not belong to Maimal community or Astral Kachar district, because this is repeatedly been raised by this the respondent number 4 also. Every time there's a tender, they'll come with this plea. My lord, next. This being the settled position regarding appellant, respondent number 2, in our considered opinion, committed gross illegality in rejecting its tender on the ground that its members do not belong to Maimal community of Astral Kachar district. We are also unable to agree with the learned single judge that earlier finding of this court about the members appellant from Kachar district was not authoritative pronouncement. More particularly, when the finding had the seal of approval from the Supreme Court. It is unfortunate that state government, having admitted the position of appellant before Supreme Court, that its members belong to Maimal community of Astral Kachar district, reacted this tender by taking an altogether incorrect opposite stand. This act of respondent 2 is apparently contemptuous and has caused heavy loss to the state exchequer. We accordingly set aside the order dated 11/7/23
passed by respondent 2 as well as order dated 28/10/13 passed by a single judge, which also direct respondent 2 to immediately take a fresh decision in the matter of settlement of fishery by treating the appellant eligible the settlement, the present appellant. The appeal is allowed with a cost of rupees 5,000, my lord. This is what has happened, my lord. We came to the picture, we are running the fishery. Now, please come to, my lord, page number 60, my lord. How presently we are allowed to run the fishery after the expiry of the term? There's some reason behind that. 80% fishery area has gone to the Orang fishery, my lord, sanctuary. 20% remain. That's why, my lord. Page 60, my lord. That was the order. The validity of the settlement of number 2 Brahmaputra Mill Samiti, Mill Mahal, situated within Dolgao and East Mongolde Revenue Circle of Dharan district will expire on 5/7/23. As per government instruction, 80% of number 2 Brahmaputra fishery has already been handed over to the Orang National Park. Therefore, the sitting lessee is allowed to run the remaining 20% of the fishery temporarily with effect from 6/7/23 by fixing 2100 on daily basis until further order received from the government to abandon loss of fishery revenue by assessing the revenue of rupees 37 lakhs, my lord. 1,000 such for 20% of the fishery, my lord. The fixed fishery revenue will continue to increase by 10% per annum, such, my lord. This is what. Now, after this order was passed, my lord, the impeded order was passed, rejecting this one. That's in page number 66, my lord. Order dated 1/9/23, my lord. Page number 66. Let me read this, my lord. Order of DC Dharan such. This is regarding running of 20% area of Sutia Brahmaputra fishery in Dharan district on daily basis on expiry of existing lease till regular settlement of 80% of the area of the fishery now falls under second edition of extended Orang National Park with only 20% falling outside the national notified area as intimated by the DC Dharan by letter dated 29/5/23 with notification issued by environment such. In this connection, government revisited the matter of daily basis running of the fishery in terms of order issued by DC Dharan by order dated 22/6/23, whereby the existing lessee Bagpuri Maimal Samiti Ui, my lord, allowed to run the fishery at the rate of 2,100 per day. Now the petitioner society has offered to run the fishery at rupees 3,000. Suddenly, this petitioner means respondent number 4 present. That respondent number 3, there is the one, the blue-eyed boy. Please allow to Siganga FCS Limited to run number 2 Sutia Brahmaputra fishery in 20% area of the falling outside second national Orang Park, my lord, at the rate of 3,000 per day in the interest of government revenue until further order from the government. This order is issued in superstition of the earlier dated such superseded. Now, DC Dharan will take necessary steps accordingly for handing over possession of the fishery to the my learned friend, my lord. Now, my lord, kindly see there's an interim order passed by the Honorable Court, page number 73. We approached this by a way of writ petition, and this order was passed on 8/9/23, my lord, page number 73. First page is the fact, my lord. I can take a lawsuit to page number 74, my lord. 74. I can save a lawsuit's time, that's why. Paragraph 3.3, my lord, kindly have a look at. Pursuant to a joint verification undertaken by the responding authorities, a decision has been taken to undertake regular settlement of the fishery with 20% area of original fishery area. After assessing the revenue, annual revenue of the fishery in the rule 48 of the rules, my lord. 3.4. It is projected that as the period of settlement of the fishery expired on 5/7/23, in the process of assessing the revenue of the fishery under rule 48 of the fishery rules is not complete, the fishery had been allowed to run by the petitioner society by an order dated 22/6/23 of the Deputy Commissioner Dharan only on daily basis at the rate of 2,100 per day. It is stated that the petitioner society, after the said order dated 22/6/23, was operating the fishery by duly depositing the revenue on daily basis, even till today, till yesterday, my lord. The petitioner society is agreed by an imperial order dated 1/9/23, passed by the respondent number 2, my lord. Next, paragraph 4. The counsel for the petitioner has submitted that during 7 years period of settlement, the petitioner society had duly submitted the requisite revenue to the exchequer. Even when the petitioner society was allowed to operate the fishery on daily basis, the petitioner society was regularly depositing the daily revenue. But all of a sudden, the imperial order has been passed whereby respondent 4 society has been allowed to operate the fishery on daily basis at a daily revenue of rupees 3,000. It is submitted that there was no proper consideration as to whether the respondent 4 society is eligible to operate 60% category fishery. It is contended that in the absence of such consideration, the impending order is violation of the principle of natural justice and behind the back of the petitioner, my lord. Next, my lord, let me skip this page. Next page, paragraph 10, my lord. That's the important paragraph. Page number. Two more small paragraphs. A perusal of the impending order dated paragraph 10. 11093 doesn't prima facie go to indicate that there was any prior consideration on the part of the respondent authorities in the fishery department on the aspect of eligibility or otherwise of the respondent for society to be settled with 60% category fishery, either on regular basis or on daily basis. On the other hand, it appears prima facie from the above facts that petitioner society had earlier been settled with the fishery for a period of 7 years, and there was no default on the part of the petitioner society in depositing the revenue of to the state exchequer. It is eligible to be settled with 60% category, and it was not provided any prior opportunity of hearing on the enhancement of the daily revenue. Though earning of higher revenue is one of the relevant factors, it cannot be the sole relevant factor in the matter relating to distribution of public largesse, state largesse, more particularly in a matter relating to settlement of 60% category fishery. Having considered all the factors, this court is considered of view that petitioner society has been able to make out a prima facie case that a similar opportunity like the one given to the Resma 4 society as well as daily revenue should have been given also to the petition society prior to passing the impending order dated 1923. In such view of the matter, it is observed that till the returnable day, impending order dated 1923 is hereby suspended, my lord. Then, my lord, the other side has final application of vacation of the stay order, and the impending order was passed, page number 244, but the operative part will start from 246. In fact, 247 lordship may come to 247, my lord. 247, paragraph 3 you can skip, my lord. Paragraph 4, my lord. In council for the submitted that earlier order dated 26/23 by which petitioner?
Right. Just
My lordship. Which the petitioner was permitted to operate the fishery on daily basis was cancelled without giving any opportunity. My lord, page 247, bottom, page 10. Counsel for the petitioner submitted that or earlier order dated 22/6/23 by which the petitioner was permitted to operate the fishery on daily basis was cancelled without giving any opportunity, and therefore there was gross violation of the principle of natural justice. He submits that right had accrued upon the petitioner to operate the fishery by virtue of the order which has been superseded by aforesaid impending order. He submits that petitioner is agreeable to offer the same rate, and therefore an opportunity was required to be given to the petitioner. With regard to the right of the petitioner society to be granted the settlement of fishery in question vis-a-vis the statutes holding the field, namely provision 12 to the fishery rules, he submits that the issue has been settled in the earlier round of litigation, wherein a division bench of this honorable court by order dated 2/6/16 passed in number 347 has held that members can be belonging to those of the Maimar community of Astral Kachar district. Next, my learned friend submission, my lord, senior friend. Per contra, senior counsel has for the Resma 4 submitted that the term of the earlier settlement with the petitioner having admittedly come to an end on 5/7/23, the initial order dated 26/23 by which extension was granted to the petitioner was itself illegal. It is submitted that although the aforesaid order was said to be temporary arrangement on a daily basis, a reading of the same would reveal that the same is nothing but an extension, as there is a contemplation of enhancement of the rate after a year. It is submitted that even if the process of demarcation and fixation of the new boundaries would have taken time, the temporary arrangements also required to be done fairly. The issue of lack of jurisdiction and power on the part of the deputy commissioner has also been raised by contending that under the fishery rules, power of settlement is vested only with the government. Justifying the order dated 1/9/23, the senior counsel submitted that order has been passed by the authority having jurisdiction and upon an application made by the respondent 4. It is submitted that even the rate at which respondent 4 has been allowed to operate the fishery temporarily is higher than that which was fixed with the petitioner. It may be mentioned that it is mentioned that while the rate fixed with the petitioner was 2,100 per day, that has been fixed with the respondent 4 at rupees 3,000 per day. Therefore, public interest has been served. My lord, then paragraph 10, my lord. paragraph 10, it is however required to record in this order that learning counsel for the contesting parties as well as the learning standing counsel for the department not dispute with the proposition that rule in question as well as the interest of justice will be required certain fishery in question on a regular manner by calling over bids. Yes, my lord. 11. Though the rules holding the field do not vest any power with the deputy commissioner to make any settlement of the fishery, this court is of the view that the order dated 2026-23 was passed to meet the exigency as a part of the fishery was included in the Orang Fish National Park, and without ascertaining the boundary, a fresh process of settlement was not able to be initiated. At the same time, the contemplation of enhancement of the revenue rate by 10% per annum may also give rise to an apprehension that arrangement, though said to be temporary in nature, would continue for at least a year. Such arrangement would be wholly in contravention of the rules. As noted earlier, Deputy Commissioner of the district is not the prescribed authority to make such settlement of fishery as is a power vested with the government. Just suppose the order dated 1/9/23 by which the Resma 4 has been allowed to operate the fishery by temporary arrangement on a daily basis is passed by the department. Reading of the said order also doesn't lead to a conclusion that there was any contemplation to continue with the arrangement perennially. The rate in which the arrangement has been done on a daily basis with the 4 is also more. Though the argument has been made on behalf of the petitioner regarding Eddie's violation of the principle of natural justice, this court is more not inclined to accept the same as the petitioner itself was beneficiary of such or action which was manifested by order dated 2026-23, wherein the petitioner was allowed to operate the fishery on daily basis even after expiry of its term. Under those circumstances, this court is of the opinion that petitioner will not have locus standi to make the ground of violation of natural justice while challenging the order dated 1/9/23. In view of the above, this court is of the opinion that interim order dated liable to be vacated is accordingly done. Next, my lord. Having held so, the court cannot be oblivious of the fact that the procedure of settlement of fishery is laid down in the rules which do not contemplate any temporary arrangement. It is true that a given situation, exigency may acquire a temporary arrangement, but such arrangement cannot be converted into a permanent arrangement. The earlier term of settlement had expired on 5/7/23, and by this time, more than 5 months have elapsed. Therefore, the exercise for ascertaining the boundaries of the fishery in question after inclusion of parts of the same in the Orang National Park is required to be completed as early as possible. In view of the above, this court, while vacating the interim order dated 8/9/23, is also of the opinion that order dated 1/9/23 cannot be allowed to operate in perpetuity. Therefore, the writ petition is disposed of with the following direction. 1. The exercise of ascertaining the boundaries of the fishery in question be completed expeditiously, and in the event within a further period of 1 month from today, as more than 5 months have already passed from the date of expiry of the earlier settlement. Immediately on completion of the aforesaid exercise, the fishery in question may be strictly settled by following the procedure of law. My lord, no problem about this first one and two. The next. The order dated 1/9/23 by which the Resma 4 has been allowed to operate the fishery on daily basis would continue for a period of 1 month, by which time the exercise of demarcation has been directed to be completed. This is what, my lord, the offending person, my lord. Replacing me for 1 month, the Resma 4 has been brought in here, my lord. Next paragraph, my lord. In the event the exercise for demarcation is not completed within the prescribed period of 1 month, the fishery may be operated on temporary arrangement for a further period, which may be extended to a further maximum period of 2 months and no more. Such temporary arrangements, however, is to be made after notice, whereby all intending eligible parties may offer their rate in keeping in mind the public interest. That's the case, my lord. My lord, I am agreed by about the clause number 3, my lord. Since I was a sitting lessee, I have been operating even for this extra period also till today. I have not defaulted in payment of every revenue, my lord. Even debut yesterday also I paid the revenue, but it's not fault, my lord. My lord, whatever rate has been offered to my learned friend, my lord, Resma 4, my lord, I am ready to pay that also, my lord. At least, government being a, my lord, the mighty government, my lord, before cancelling this order, was not incumbent on their part to issue notice, my lord. The minimum requirement of anything, my lord, is notice parties, my lord. Lordship is always held this notice for doing any act. Have the notice, ask him, this is what. First day, the same respondent who was respondent number 3 in the writ appeal, my lord, writ petition, my lord. The same person, entire Dorong district, only respondent number 4 is there. Is there nobody else? He has been brought in and again given the settlement. Why, my lord, my lord? At least the notice may be given. Even, my lord, under the rules, eligibility criteria, neighborhood, All the petitioner I have fulfilled, my lord, not he. Had he fulfilled the criteria, he could have got a settlement, my lord. He also doesn't get that, my lord. On what ground, on what basis? Without notice, my lord. All of a sudden, the government found respondent 4. He is eligible, my lord. He filed an application, it was given to him, my lord. That's why my submission, my lord. Roasting me, my lord, with the same rate may be offered to us, my lord. For 1 month, if it is, my lord, who will disturb this petitioner, my lord? He's continuing, my lord, without any complaint. He's paying the revenue, my lord. Let him continue for 1 more month, my lord. What is there, my lord? That's my submission, my lord. Rest leave to lordship, my lord.
But I wonder, what is the right of the petitioner? And now, what the illegality he wants to show to this honorable court in the order that has been passed by the learned single. Lordship will kindly bear in mind. This was a purely temporary arrangement made. A lessee is operating for last 7 years. His term has come to an end. Can he claim that I have a right? I must be heard before giving it to someone else. Can he claim that I have a right to continue even for 200 days or 2 other months? What is the right? I fail to understand. That's why the learned single judges dealt with this point. His term is over. He has become functus officio. But the deputy commissioner exercised an authority which is not vested on him. He passed an order allowing him to continue on daily basis. Kindly see the order. Lordship has seen this once more. Is there any reason? Was it that nobody has come forward to take it and hence I have given it? 2,100 per day he was given. But Deputy Commissioner has no authority and said that this will again be increased by 10% in every year. That means it is a longer arrangement made.
Where is that fishery rules?
Fishery rule, Lordship will see, it is the rule 12 only allows the state government to settle. And when this term expired, I made an application before the government that look, you are not going to settle it now, at least temporarily allow us. Rule 12. Proviso. Page 14 melody in this book. Provided that the Rule 12, provided that the government shall settle a 60% category fishery with a special category of cooperative societies, non-government organizations, and self-help groups, constituting 100% actual fishermen in the neighborhood of the fishery concerned by the tender system. This is the normal rule.
What about Rule 8?
Rule 8 speaks about settling authority regarding other 40%. 40% fisheries.
40%.
40% fishery can be settled by these authorities, district deputy commissioner, additional deputy commissioner, they have been entrusted with. But so for 60% fishery reserve category, they are to be settled by the state government. Now, therefore, my lord, firstly, the order which was granted by the deputy commissioner in favor of my learned friend's client was without jurisdiction, without authority. It was not in the nature of a temporary arrangement, but this was issued as if this was a perennial arrangement made until no time limit fixed. He had not made any application even to the appropriate authority. Therefore, when the term comes to an after 7 years, kindly see, one party is possessing for 7 years. Then it is for the authority to decide how to make arrangement for a temporary period. I made an application before the authority, and the authority considered it and granted me. And with a direction that you, meanwhile, Deputy Commissioner, you meanwhile assess it. Fix the rate, so that fix the boundaries, fix the rate, and so that we can go for regular settlement. And therefore, regular settlement is offing. But then during this period, at the price of 3,000 per day, I was asked to run the fishery. And he has put a challenge to this. And with all respect, the learned single judge, on certain extraneous considerations, irrelevant considerations, granted the stay order. They have run it for 5 months. Thereafter, even after expiry of the term. Now he wants that he only will run it, no one else should be allowed to come in. That is the approach. And who is the blue-eyed boy? Kindly see. Abusing the rules, abusing the power, he has been allowed to run beyond 7 years, and for more than 5 months he is running now. He was dislodged only the other day. After the order of this honorable court, the authority has handed over the poison to me. And I am only to see for 1 month. The direction of the learned single judge is very clear. Kindly come to it again, Mali. What it says, we have allowed you, because the first order granted by the Deputy Commissioner in favor of the writ appellant was already cancelled by the government. And it was given to me, therefore that order was not in existence at all. The order which was granted by the Deputy Commissioner in his favor was already cancelled by the government and then allocated to me. Therefore that order doesn't exist anymore. When he put to the challenge, only by virtue of an interim order of this honorable court, the learned single judge's order, he used to continue, though he had no right to continue. By an interim order of this honorable court of the learned single judge, he could not have been asked. He has not been allowed to ask, and he could not have been allowed to continue. There is no order in his favor. The order which was already passed by the Deputy Commissioner was already cancelled by the government. Even then he continued. Therefore, the learned single judge has said that the order which was passed in his favor by the Deputy Commissioner is of a perennial nature, as if a permanent arrangement has been made, which power he didn't have. And there is no question of it. Violation of natural justice. What right he has that he is to continue for another 5 years, 7 years. So before dislodging him, he should be heard, a notice should be given. What is the cardinal principle here? Government has made an arrangement, very temporary arrangement. That temporary arrangement, government can always make. The appropriate authority has taken the call and has passed the order. Therefore, the learned single judge has again said that even that should not continue further. That should also be restrained to only 1 month. Very fair order. I am not opposing it, yes. If the normal process of settlement is undertaken, everybody will be able to participate. I will also participate. He will also participate. But meanwhile, till that process is initiated and the learned single judge has restrained it to 1 month, and thereafter if you fail to assess, then you will have to again make this temporary arrangement by giving notice to everybody. Well, I will respectfully submit. Well, the extreme fairness, the principle of fairness has been kept in mind by the learned single judge while passing this order. It needs no interference. There is no illegality in my respectful submission. There is no illegality. He doesn't have any right on that. Rest are all irrelevant. Whether he belongs to some community or that, those are not the questions here. He got on that basis, he got the settlement for 7 years, he has run it, he has completed the term, gone. Whether he is paying or not paying, whether he is a defaulter or not, that will be taken care of the next settlement only. Now, for the learned single judge also, there was no occasion to record he is not a defaulter. Who knows? Who knows whether he is defaulter or not in the earlier term? So therefore, all these are irrelevant things. No compassion should be shown to him, and there is no right on his favor to claim that let me continue for until you make any other arrangement. Therefore, my respectful submission is this order is very temporary and temporary arrangement can always be made, and there such questions of giving notice, hearing parties, those will not arise, more particularly in the facts of this particular case when he has completed his term and he should have at that time leave it and make it open. Therefore, my respectful submission, there is no ground for staying, and his particular point is that why should I be given? Well, that cannot be, that should not be. That should not be the approach. That means he is the only eligible candidate, he is the only eligible society who should be always allowed to run. It is not. There are other people and these are state lodges. The authority must see that those are distributed in a fair manner. It is not confined to only one. That cannot be. Therefore, my lord, the order ex officio of the learned single judge needs no interference. No question of any stay. I will respectfully submit that lordship will not grant any stay. It will prejudice not only my interest, it will go against the law. That is my respectful submission.
Yes, take it up.
This is purely a stopgap arrangement, my lord, only for a period of 1 month. So for my lord, other part of the direction in paragraph 16, is 151 is concerned. Perhaps those are.
No, my lord, no grievance except clause 3, my lord, paragraph 3, no grievance.
And so for my lord, clause 3 is concerned, that is only a stopgap arrangement, my lord. And admittedly, my lord, perhaps my lord, appellant also admitted, the deputy commissioner did not have any power to, my lord, curtail the fishery. So far it is.
Disposing of this week, my
Only my submission is the last
And
one
the
sentence,
process
short
has
sentence, my
already
lord.
been initiated. Tender has not yet issued. The process has already been initiated pursuant to this direction of the learned single judge.
One shortest submission, my learned friend repeatedly said what right I have got, my lord. Under this book, what right he has. Or any book, what right he has, my lord. In entire Dono district, only one person. That's one number 4.
I'm not gonna. DK Sharma, you are appearing for?
1,
3 also you are appearing? DK Sharma. 1, 2, 3, KK Manda, etc. And become. Will dictate the order in the chamber is dismissed.
My lord,
Applies, my lord.
Item 21.
I don't know. My lord, in regarding item number 21, I have filed a caveat. And may I pay that, can it be taken up tomorrow, my lord? Because it's a very bulky, my lord. Yesterday at night, I received that, my lord. Tomorrow, your lord. Tomorrow, my lord.
Okay, heard DJ Martha, the caveat, senior counsel for the caveat, tomorrow, caveat is discharged. And in which appeal heard as protocol and on request by the DJ Martha, the counsel appearing for respondent.
Respond to my 5, my lord.
5. List the matter again if tomorrow is 21.
Tomorrow, my tomorrow. Obliged.
Item 13 for orders.
May it please your lordships. My lord, আমার হয় না হয়
Unfortunately, read petition was dismissed for default. Thereafter, we have filed an application for restoration. And restoration petition is before your lordship. During the COVID time, this petition was dismissed. And my learned friend has got notice and he has appeared for the bank. My restored submission, lordship may restore it.
When was it dismissed?
It was dismissed on
29.
23/9/2020.
23,
At
9.
page 8, lordship will find of my IA, page 8, that order.
Page 8.
Page 8, my lord, of the IA, 1777.
Is this IA on time?
I was on time,
IA on time is very limited.
within limited time, yes.
Within limited. Yes, can you heard Mr. K.K. Mahanta to the assisted by Mr.
K.M. Mahanta. K.M. Mahanta.
K.M. Mahanta, let us come to the application.
I am for 1 to 3.
Also heard Mr.
P.C. Goswami.
P.C. Goswami, let us come to for the Indian Overseas Bank Public Respondents 1 to N. So, by this application, the applicant is trying for restoration of WBC number 6055 of 2015, which was dismissed. You were absent all this while.
My lord,
See the order
yes,
23/9/2020. That day you did not appear. On 15/6/2020, you did not appear. Then it says the matter has become infracted.
my lord, that time, the COVID time, therefore, there was some people are not coming to the court. Therefore, the difficulties arose, my lord. During that time itself, it was done.
This is not this is not dismissed on default.
This was dismissed.
See, page 9.
Become infructuous. The petition stands closed. However, with liberty to the petitioner to approach this court again if so advised. So we are coming, my lord. This has not become
Not
infructuous.
by way of this, you may have to file a review application.
No, the ultimately it is dismissed being infructuous.
No, it is closed as infractures.
Yes.
Because see, on top also you see in the it says none appears for petitioners on call heard so and so. Mr. So and so correspondent for it is submitted as bar district petition has become infractuous. However, since petitioner's counsel is absent, we are inclined to grant one more opportunity.
No more interested.
So you'll have to file a review saying that matter is not infractuous.
Well, yes, technically speaking, Lordship is right.
Yeah.
But I think here also Lordship can take the call. Because ultimately, it is to recall this order and to bring the original case into record. So that, therefore,
I don't think that. File a review.
a review Yes, my lord, as I say, strictly speaking on technical grounds, yes, it appears to be so. It was not a dismissal simpliciter on default.
Correct.
But saying that it has become infractious, probably we are not interested to pursue it anymore. That was what the court view was.
Supposing we pass any order in this IA, we will be also committing some mistakes. Court would also-
My lord, going by the explanations given in the petition, lordship will have this.
There's nothing.
Going by the explanations given in the petition.
Why don't you file a review?
My lord, it was taken as a dismissal on default. That was how. That was how. That was how it was taken as a non-appeared dismissed for default. That was how the mistake arose. We have explained the non-appearance. We have explained the non-appearance, my lord. Paragraph 2, 3, 4. Simply on that, but it has not become infractious. Non-appearance has been explained.
No, these are the reasons for restoration.
Yeah.
But then you should give the review saying that the matter is not infractious.
Yes.
So that difficulty is there.
Then in that case, we'll have to go for only that infractious, whether it has become
Yeah.
infractious. We'll press petition, we'll file.
You can withdraw this and file a fresh
We say liberty to file.
appropriate application. K.K. Mandal and Senior Counsel, assisted by so and so. For the applicant, press for withdrawal of this IA with liberty to file an appropriate application. Mr. So and so, Learned Counsel, appears for so and so, huh? IA is accordingly dismissed on withdrawal with liberty as prayed for.
Obliged.
14.
May I please, Lordship? I mean, person, Lordship, a notice yet to be, my lord, the service is awaited, my lord. Respond number 3 to 6, my lord. Lordship may post it in the month of January, my lord.
When was it sent?
My lord, it was sent on 21/11/2023, my lord.
When did you take steps?
My lord, we have taken step immediately, my lord. My lord. 17/11, my lord.
17/11. So now it's more than 1 month.
1 month is over, my lord.
Yeah. Three to 6. When notice is not complete, why did you mention it then?
My lord, because that last date was 9th, my lord, it has to be listed after 4 weeks, my lord. Therefore, my lord, 9th to 12th, the time was over. That's why, my lord, just to get the position clear, my lord, whether party appear or not. I mentioned.
You take first steps then. Mr. Chamaria, Leonard.
Oh, Lordship may wait for some time. Might be, my lord, the AD will come. One date, my lord.
Hmm?
One date may be waited, my lord.
Okay.
My lord, in this matter, I appear on behalf of an intervener, my lord. The Assam State Legal Services Authority has requested my senior Mr. P. Mohanta to appear pro bono in this matter, my lord.
In which 4D?
My lord, what has happened is that
No, for which respondents?
I am not agreeing on behalf of the any one of the respondent team.
Then then?
One lady has my lord, we have just received a notice from the Assam State Legal Services Authority, my lord. One lady has approached the Assam State Legal Services Authority stating that she is interested in the matter and therefore she has.
So you file an intervener application?
My lord, I will file, my lord. I
For
will implement.
Without that, you can't.
My lord.
Mr. Chamaria, Leonard, petitioner in person. is allowed to take first steps for service of notice on the respondent number 3 to respond number 6 by registered post again,
Registered post.
registered post AD within a period of 1 week.
Yes, ma'am.
Office will be open
Ma'am, we'll take.
within a period of
Ma'am.
1 week.
But only thing is that respondent, the government may be directed to file the affidavit. The affidavit is essential, madam.
Is
Failure
there-
of-
Need of the, my lord,
in that-
Observation, maybe.
other respondents, they are mainly agreed.
My lord, they are,
Government advocate appears for respondents 1 and 2. This again after 4 weeks.
but the affidavit, my lordship, can note down, my lord, because their
They are saying they are not interested.
Not interested, my lord, but the other respondents are very much necessary.
no, but their role is
Because they
very,
are agreed, my. We'll also file our again.
will not have harm, my lord.
After 4 weeks, in the meantime, the respondent 1 and 2 shall file their
Man.
respective affidavits.
Please, your lordship. Lordship, service on respondent number 3 and 4 has not been completed. It was sent on 8/12/2023.
8/12.
Right.
Okay, heard MS
A.N. Hussain.
and Hussein Learned Counsel for the petitioner.
Yes, lordship.
Await service report on the respondents
3 and 4.
3 and 4. And list the matter after 2 weeks.
Okay.
17.
May I please, your lordship? I is for condonation of delay, my lord. It's delay of 12 days, my lord, for filing the writ appeal, my lord.
Bora,
It's up to my lordship.
I have explained my delay in para 4, 5, 6, 7, and 8, my lord.
heard Mr.
As Hazarika, ma'am.
Learned Counsel for the applicant. By this application? No, cancel it. Also heard MS MD Bora, Learned
Standing counsel cooperative.
Cooperative Department.
Cooperative.
For the respondents,
1, 2, 3, 5 and 6, madam.
1, 2, 3, 5 and 6, and Ms. Landas for the respondent number
4.
4. Stop.
7 notice, madam.
By this application, the applicant is praying for condemnation of 12 days delay in filing the connected with appeal. Stop. The cost. We have considered the question. At paragraphs
4, 5, 6, 7, and 8, my lord.
4, 5, 6, 7, and 8 of the present. And we are satisfied. Accordingly, delay of 12 days in filing the connected to appeal is condoned. Registrar is directed to number the with appeal and use the matter in its usual course.
Copies to be served, my lord. Copy of
It will be registered.
Obliged,
You serve copy.
my lord. But at the time of filing, we.
No, no,
serve-
government.
4. I'll serve.
Obliged.
Obliged, my lord.
Item 18 and 19 for hearing.
My lord, any date as per my lord's discretion may be fixed after the vacations.
No, my lord, what happened in this case, my lord? Lordship, kindly see order sheet. They have taken time for 8 to 10 occasion, my lord. And this is a case where, my lord, the term of the office of the president of Jilla Parishad is going to be over by this month. So, Honorable Single Judge has passed an order in my favor, where I was allowed to hold the charge of president of Jilla Parishad. My lord, that is going to expire, term is going to expire by this month. So, my lord,
My
we
lord,
have the urgency-
my lord, on the last date, without taking our consent, they had fixed the matter for today.
On reaching the matter.
They had not taken us into
My lord,
confidence.
My
on
lord,
the last date.
my lord has
The
passed the
videos
order,
will be
last
checked.
order, my lord, lordship kindly see, on reaching the matter, they are absent. And
They never took up
my senior counsel, my lord, Kain Chaudhary has fixed the matter today, my lord. Considering the urgency, this honorable court was pleased to fix the matter today, my lord.
No, at least they should have.
My lord, on reaching
basic
the matter.
courtesy of informing us before taking a
my
date, my
lord,
lord.
on reaching the matter, this is not necessary for us to take permission. We have not mentioned that in the morning, my lord, at 10:30, my lord.
Learned Advocate General would appear in this matter, my lord, personally.
That is the, my lord, there.
But if December is over, then
Yes, my lord, everything will impact us, my lord.
become infractors.
My lord,
it could have.
And my lord, in this case, additional advocate general, Mr. Kaur also appear, my lord. He can appear today or tomorrow, my lord.
Please don't invite. Lordship, what is the problem, Lordship? They could have fixed the matter prior to, I mean,
Yesterday, otherwise.
Day before yesterday, my lord, matter was fixed.
But today was a day when he has got prior
My
commitment.
lord, Day before yesterday, lordship fixed the matter today, my lord.
On last occasions, Lordship, it was not our prayer only, Lordship, it was a joint prayer. Because on
My lord,
last
only
three
two
days,
occasions
Lordship-
there was joint prayer. Other than that, my lord, they prayed for adjournment, my lord.
On last
Taking
3 days,
adjournment.
Lordship, both advocate.
If the
general-
matter
One
is-
side is not willing to argue, one side is saying the matter is going to become a frustrating. What do we do?
Lordship, we are willing to argue, only a problem is the advocate generally appearing, his absence, Lordship, it will not be possible.
tomorrow, my lord, or day after tomorrow, my lord.
Day after tomorrow will not be possible.
No, tomorrow, my lord, we are ready, man.
Will the AG be present?
He'll not be
Assuming that tomorrow.
Yeah.
No, my lord, if that be so, my lord, by this time, my lord, the lord
Immediately after
matter will,
vacation,
after vacation, my lord, I have the copy to show the election, my lord, first meeting was held on 28th, my lord. And if it is 28 is over, my lord, nothing will survive.
No, the notification is not out yet. The election notification is still
That
not
is
out.
not the fact.
Everything is,
That will be.
there are no dates which have been fixed
Yeah.
for the election still date. So everything is like still wishy-washy as far as the election dates are concerned. Nothing is concrete.
Lordship, I have the copy of my lord, last election certificate.
But the dates.
That is
like,
the
have
last
not been
election,
fixed.
isn't it?
The last
Yes,
year.
last election was held on, result was declared on 15th of December. And the first meeting was held on, my lord, 28th. So, my lord, in any case, by 28th, from the date of first meeting, my lord, the tenure start matter.
Yeah, I can't read this.
That is vernacular, my lord. Goswami also. My lord, that is 15th of December, certificate was issued. And thereafter, first meeting was held on, my lord, 28th of December.
You could have had the courtesy of translating this and bringing it.
Yes, my lord, I'll be after some time.
You're pulling it out from your pocket.
Yes, my lord, just I have I'll finish after some.
This is not the proper way of doing.
Just, my lord, this is, my lord, just I have collected to show before the court that my lord term is going to expire. Day after tomorrow, any day, my lord, before that, my lord. If it is so.
Yes,
ma-
and it.
My lord, first day after the vacations, AG sir won't be there tomorrow. So, and day after
That is the
tomorrow,
my lord, that is
my
the-
lord is not
for one
willing to take
ground
up the
or the
matter.
other
So
ground, they are
first day after
taking time.
vacations.
All along, they are taking time.
No, election notification has been issued or not?
No, my lord, not yet. Not yet.
But in
Dates are
terms
not
of the
yet out.
provision of the act, the tenure will be 5 years from the date of first meeting. First meeting is on 28th of December, 2018. I am the president of the Jilla Parishad. My lord, single judge has passed an order in my favor.
So hardly 1 week is there, like in
In any
between for the
case,
vacations.
in any case, I am an
There.
elected president.
There is no such urgency, my lord. If my lord would look at it.
Otherwise, lordship may vacate the stay order, my lord.
What stay is there?
On 12/6, my lord, there is an order staying the operation of the order. my lord. Lordship can 22/6/23. On 22/6/23. My lord, in the order sheet, my lord, of this honorable court, my lord, there is a stay order.
Who's the president now?
Yes, my lord, vice president is holding the charge. My lord, respondent, my lord, petitioner in my lord, item number 19, she is holding the charge. That is the, my lord, crux of the matter. She wants to carry on with the charge without having the post of president. And my lord, they are taking time all along.
If
Lordship,
not-
kindly see
if
paragraph
notifi- if
24.
After issuance of notification, it will take some time for the election.
In any case, my lord, term will be over.
Decision has been taken by the government. That election is going to be held on Sunday.
Everything is tentative,
Notification
my
will
lord.
come only thereafter, Lord.
My lord, the
Decision is there.
section,
On Lordship, what I'm submitting, Lordship, on last 3 days, Lordship, both the councils were absent. Lord. Both, I mean, learned advocate general and Mr. K. M. Chituri, both were in the Supreme Court. That is why no hearing should take place, Lordship. And it was a joint prayer on last 3 occasions. Lord.
no, my lord, we have not paid for any adjournment, my lord, on that. On the last occasions also, we are ready
But
to.
they have not, they've just come and unilaterally taken a date, fixed the matter for 20,
Once they
without
paid for-
taking us into confidence.
Then we'll list it on the opening day.
My lord,
Absolutely,
even
my
on
lord,
opening
January.
day, my lord, everything will be infractions, my lord.
I don't think
My
so.
lord,
No, no.
Lordship, kindly see section 68.
No such decision.
Section 68 of the Assam Panchayat Act 1994.
There's no case for urgency.
Section 68. State can always make an alternative arrangement, my lord.
Okay. Oath about.
Election day.
Section 68 of the Assam Panchayat
January
Act
28th.
1994.
Section
68.
7.
Panchayat Act.
Yes, ma'am.
Date of the first meeting.
Section
Till date of the first meeting.
19.
1994, my lord.
7.
In my book, it is page 76.
Sorry,
Yes.
Every Jilla Parishad except as provided in the Act shall continue for a period of which shall not exceed 5 years from the date of holding the first meeting, my lord. Here is a case, the result of the Jilla Parishad members were declared on 15th of December. Thereafter, first meeting was held on, my lord, 28th of December.
The problem is Advocate General is absent. He can't come tomorrow.
Stay maybe, my lord, that interim order may be, my lord, considered, my lord.
That we can. It's always.
That's what, my lord, tomorrow or day after tomorrow, my lord. All along, my lord, what happened, my lord, they took time, my lord.
Tomorrow AG is not available. Day after tomorrow, there's some inconvenience with the court.
My lord, the government always can make an alternative arrangement, my lord.
We'll have it on the 3rd.
I'm praying for 4th, Lord. On 4th.
Or whatever it is. If it's okay, Mr.
Day of 3rd of
Problem the tenure ends, Lord.
Maybe the tenure is ending, but then the notification has not been out.
But
So
as in terms
so
of the
it-
provision of the act, my lord, nothing will survive. my lord.
But if the appeal is dismissed from 4th to 28th, you can be the president. So you can take a chance. 4th of
You
January.
address to court.
I'm
Not
addressing
me.
my lord.
I'm not here.
Anything can happen, my lord. In case if the writ appeal is disallowed or is set aside, then he can always
My lord,
be the
then
president
my
from
lord,
4th to
court will be
28th.
handicapped, my lord, to pass order.
4th is a
to
fine
allow
day,
them,
my lord.
to allow us to continue in office because the operation, by operation of the provision of the act, I'll not be in office.
That will be difficult, isn't it? How can we interfere with this act? We'll keep it on 4th. Let's see what happens.
But no further adjournment. That lordship will indicate.
Mr.
P. Handick, ma'am.
P. Hendrik,
Counsel.
for the appellants submits that the learned Advocate General will be appearing in the matter and press for some accommodation. The same is vehemently objected to by Mr.
JMA Chaudhary.
JMA Chowdhury, Learned Counsel for the respond number.
In item number 19, I am appear for respondent number 1,
For the respond number 1. Stop.
and he is appearing on the in item number 18 for respondent.
For the respondent in item in writ April 291 of 2022. However, in the interest of justice, list the matter on 4th January. It is made clear there shall be no adjournment on the next date fixed.
Timing item 8.
Obliged.
May it please your lordship.
Yes.
It is my humble submission before your lordship to kindly adjourn the matter for the day. And maybe fix after the vacation, my lord.
Even after vacation.
Yes, my lord. My senior is currently doing a matter in court number 20.
Who's your senior BT Conward?
Yes, my lord.
On request made on.
I am appearing for the respondent number 7.
Made by me on behalf of Mr. BT Conward and senior advocate, senior counsel for the petitioners. List the matter after
After vacation,
which vacation?
after the winter vacation, my lord.
After winter or after Bihu?
Any date as per your lordship's convenience.
19th,
Lordship.
19th January.
Item 9.
Lordship.
Same,
Same.
same order.
Much obliged.
These matters, I've heard the matters. There are some gray areas. That's why I wanted the written argument. If you can submit it, we'll fix it on 8.
Yes,
So that you'll have some time to prepare. the argument.
that's better.
Okay, so just say. You give separate orders, okay? In all the items. List this matter on 8 January for submission of written arguments. In all these matters.
Just one thing, in item number 15, 16, 17 and 18,
Yeah.
we have already submitted the written arguments.
The other sides.
They have also submitted, both sides have
Okay.
submitted.
Lordship,
it.
only I have prayer in this matter, 15, 16, 17 and 18.
Mm.
There in during the intervening period, some developments are there. This matter may be listed for orders again, Lordship. Some positive development has happened in this matter.
Then can you give me the developments by way of an argument on 8?
On 8, it can be placed because this matter may not be fixed for judgment on 8. For filing of written
No, no,
argument,
I'm not for judgment. I'm going to list it on 8.
for
submission.
arguments.
Yeah.
Okay, on that.
Much of.
So all the councils, I think all councils are present.
Yes.
Okay.